Right, well, good afternoon. My name is Paul Harrison from IP21. I'm going to talk this afternoon about the different sort of protection that you've got for your ideas so that you can basically stop other people copying them. IP is quite a difficult thing to discuss sometimes because people expect it to have very sharp boundaries of what is right and what is wrong. If you imagine you've got a car, then it's relatively easy to understand if somebody steals it from you. If it's registered in your name, you've got a certificate to prove it. If anyone takes that car without your permission, you can show it's yours. But if it's an idea, it's not that easy. Copyright is more to do with aesthetic things. So it was originally set up perhaps for literature, so the wording of books, artwork, music, that sort of thing. But it can now, down the years, include also software, computer software, because software is looked on as a literary work. It communicates information from one person to the other, and somebody who understands that sort of thing will be able to read effectively the program that's going. So that's looked on as an artwork. Same with engineering drawings. They're also covered by copyright. One way that a lot of people protect their ideas is simply not to tell anybody. You keep it as confidential information, and you've got confidential information there and trade secrets and know-how. And that really is what the basis of the patent system is about. It's not completely new ideas that have never been seen in the world before. It's the gradual improvements. And those two things, the gradual improvements, you could quite happily get a patent for those, assuming there's nothing else out there. If you have a software-related invention, if you have an app, and we have lots of patents going through and granted for apps, so but you have to just be careful how you phrase this and how you get it through the patent office. Really, a trademark is your badge of origin. You must be able to distinguish the origin of your goods and services from other people, so it's got to look different to others. And okay, you could get a trademark, something that's close to somebody else's, but why would you? Because then you might risk confusion. So try and make it something that people instantly recognise as yours. It was originally designed for the spare parts industry, such as exhaust pipes. So if yours, again, looks different to anybody else's, you're going to get a limited right purely by virtue of it being there. There's no registration process for unregistered design right, but registered design right, there is a registration process and fees to pay. The advantage of registered design right over unregistered is similar to registered trademarks and unregistered. It's a lot easier to prove. Unregistered design right, you have to prove that somebody's copied yours. And that might sound simple, but in practice, it isn't. And B, you try and put, if it's a computer program, then put a cartographer there and put a mistake in there which doesn't influence the program at all. But if somebody just lifted your program, then it would be they'd have a hard time explaining why that strange line of coding was in there, which meant absolutely nothing. It does cover software. It can cover databases. If you're building up a database of, say, clients, that can be covered by a database right, which is similar to copyright. The important thing for copyright is just keep good dates, good record keeping, so that if anybody does actually take your work, your copyright work, you can show that on a particular date it was here. Try and show who has access to it, which is easy to do at early stages, obviously not later on. And then it makes it a lot easier in trying to enforce your rights.